My name is Chris James. I'm the Director of our Aboriginal Lands Trust Investment Program at the Department of Planning, Lands and Heritage and Project Lead for the Amendment Bill. And I'm joined by my colleagues from the department. We have Emma Crean, who is a lawyer and instructor on the project, and Watana, who is a lawyer in Emma's team. And we've also got Twee and Brady, who are project officers in the Aboriginal Lands Trust Divestment team. Today's session is intended to provide you all with an overview of the draft of the amendment bill and give you an opportunity to provide some feedback on the proposed changes. The bill is targeted at providing changes to support the transfer of the Aboriginal Lands Trust estate into the direct control and management of Aboriginal people. And the exposure draft was made available online in full from 3rd of August, along with a range of supporting materials to support your review on Have Your Say WA. And written submissions can be made on the bill until 4 September. In terms of today's session, as it's an online session, we'll begin with a presentation outlining the background of the project and talking you through the key amendments of the bill, which I expect to take about an hour, maybe just over. To help the presentation run smoothly, we ask that you submit any questions through the chat function on Teams. Your cameras and microphones will be locked through the presentation, but there will be an opportunity to use the raise hand feature at the end, and we can turn your microphone and camera on then to have a discussion and ask any questions. We will also be recording the presentation today to make it available for online for those who've missed it. However, we'll end the recording at the end to give you an opportunity to run through any questions. We've also set aside, at the end of the presentation, the team will have been recording questions. We can go back to any slides and we'll read out all of your questions received and answer them then. And then there'll be time to use that hands function to ask any questions in person as well. And just lastly, before we begin, I've been working on the Aboriginal Lands Trust Investment Program for the past 5 years, and we've had the opportunity to speak with many of you and many of your stakeholders, Aboriginal corporations, native title holders and communities about the challenges with divestment and particularly the challenges in the Act. And the amendment bill we're consulting on today has really been heavily informed by all of that feedback and all of that engagement with you and your stakeholders. I also want to acknowledge that many Aboriginal people and corporations have been advocating for divestment for a very, very long time, and there's a really strong desire to see divestment happen. And the amendments we're discussing today are focused on making divestment easier and providing a legislative framework for the divestment of Part 3 reserves. However, we do recognise there are other challenges with divestment of the ALT estate that Aboriginal corporations have consistently raised with government as well. These include matters relating to contamination and remediation of issues on the ALT estate, as well as a need to help support the capacity of Aboriginal corporations who will be accepting the management of large-scale areas of land. And that's something we're working on separately as government as well, and I'll talk a little bit about today. While those issues extend beyond the scope of the amendment bill itself. Today's focus is really going to be on the exposure draft and what's changing, and we welcome any feedback on the bill itself, but also any broader observations you'd like to share through this process will be communicated to government as well. So getting into the presentation. Firstly, I'd just like to acknowledge that we're here in Perth, meeting on the lands of the Whadjuk people of the Noongar Nation, and pay my respects to elders past and present, but also to acknowledge all of the lands of the traditional owners of the country you may be joining us today, and that the ALT estate itself spans across the state of WA, and many, many different Aboriginal people have a strong interest in this land. So I pay my respects to their elders past and present as well. So in terms of the outline of the presentation today, we're going to start with a bit of a background on the project itself and a bit of background on divestment, because it really sets the scene for some of those challenges with handing the land back. And then part two will be a guided review of the key changes under the exposure draft. It's not all of the changes in the draft, which are available online, and there's an explanation guide there as well. However, we want to talk through practically how those key changes will work. And then part three will open it up to the feedback and questions and answers as well. Starting with the project background. So in terms of what's been released, from the 3rd of August, we've got the exposure draft, which is the marked up copy of the changes to the bill in full, along with an explanation guide, which goes clause by clause explaining the policy intent behind each of the changes. There's also a number of fact sheets to support a review, frequently asked questions, and a survey form for those who want to submit any feedback on the amendment bill. However, we're open to receiving feedback in any form you prefer, including any other written submission. And there will also be a presentation recording of this presentation online. If you have any other members or stakeholders who would like to get more familiar with the project, please direct them to this presentation, which will be on our website. In terms of how the proposal has been developed, the amendment bill itself relates back to government's 2017 election commitment to divest, hand back all of the land in the Aboriginal Lands Trust estate. And in 2019, our department first received some limited funding to start administering a divestment program. And we've been working with native title holders and communities across the state since then on various divestment proposals. And since then, we've divested 28 properties into Aboriginal control and management. However, from that engagement, a lot of corporations have pointed out some of the key issues in the Act that are making divestment difficult. And as a result of that feedback, government proposed amendments to the Act in March 2022. There was then a first round of consultations on that amendment bill from April to June 2022, and we attended 13 regional locations presenting on the key changes. Then there was a bit of a gap due to full legislative agenda. However, drafting of this amendment bill commenced at the beginning of this year, and we have been undertaking early stakeholder engagement since April this year and provided briefings to many of you on the high-level changes. And we now are at the point where we have the exposure draft itself available. And really, this is the opportunity for you to review the changes and the drafting in the bill itself and to give us feedback on what the bill looks like. Feedback is due by 4 September and will be used to inform the next draft, the final draft of the amendment bill, which is intended to be introduced into Parliament later this year. So really encourage feedback. And as I'll talk to in a moment, the feedback has already heavily informed and changed how the bill has been drafted. So it really will have a direct impact. In terms of what has changed, the first is that when we originally consulted back in 2022, it was proposed that we would remove the power to proclaim new Part 3 reserves. And this was on the basis that government hasn't proclaimed one of these Part 3 reserves since 1986. And given the intention of government is to hand back land to Aboriginal people, it made sense to remove the ability to add new land into the ALT estate. However, we've received very strong feedback from Aboriginal stakeholders that that power needs to be retained because there might be areas that adjoin some of those existing Part 3 reserves, some areas of unallocated Crown land or other tenure that would benefit from being included in those Part 3 reserves, noting that the bill now provides an opportunity to divest those as well. So that proposal has been withdrawn, and there will now be no change to the power to proclaim new Part 3 reserves. That will remain in the bill. The second big one that came from Aboriginal stakeholder feedback was changes to enforcement provisions. I'll talk to this a lot more in detail, but originally we hadn't looked at updating any of the enforcement provisions. However, strong feedback was that the penalties for trespass on Part 3 reserves weren't strong enough. And we've now got a number of changes in the Act that seek to enhance offences. And the last one to just briefly touch on is the dissolution of the ALT. original proposal was to provide in the amendment bill itself for the ALT to be dissolved once all of the land has been handed back. However, since then, and in working with Aboriginal corporations on divestment, it's become apparent that divestment itself might take a very, very long time. It can only occur where Aboriginal stakeholders are ready and where government has built up the capacity of those corporations to manage the land, and also where government has effectively remediated all of the land. There may also be portions of land in the ALT estate that are subject to services or rubbish tips or contamination that are better managed by the ALT. So the amendment bill itself will no longer provide for the dissolution of the ALT. However, it would still be the intention that if and when we do get to the point where we've handed back the ALT estate, then we can find a mechanism to dissolve the ALT. So that's a bit of a high-level background on the amendment bill itself. And then next, I just wanted to give a brief overview of the divestment program, which informs some of those legislative challenges for divestment. So the divestment program itself is governed by this Act, and the Aboriginal Affairs Planning Authority Act introduced 4 statutory bodies, being the Aboriginal Affairs Planning Authority and the Aboriginal Lands Trust. Both of those bodies hold land on behalf of Aboriginal people, and we refer to any land held by those bodies as the ALT estate. The other 2 bodies, the Advisory Council and the Coordinating Committee, they are controlled and managed by the Department of the Premier and Cabinet and provide broader consultation services with Aboriginal people. And the amendment bill doesn't propose any amendments to those 2 bodies. Our amendments in the bill are focused on the land functions and making divestment easier. This slide is a snapshot of the Aboriginal Lands Trust estate today. So there's 285 properties, and those properties cover 21.9 million hectares of land, being close to 9% of the landmass of WA. So a really significant portion of land. Really importantly for the amendment bill, 81 of those 285 properties are reserves that are proclaimed under Part 3 of this Act. And I'll talk a lot more about what those Part 3 reserves are and why they're special. But they make up 93% of that landmass of the ALT estate, which means they're really, really important if we want to find a way to hand back all of the ALT estate into the control and management of Aboriginal people. We need a way to hand back those Part 3 reserves. So moving into this map now shows those Part 3 reserves. So you can see that they're the large majority of the land. There's a lot out in the Central Desert region and up in the Kimberley and the Pilbara. And Part 3 reserves are Crown land reserves under the Land Administration Act that have been proclaimed by the Governor under Part 3 of the Aboriginal Affairs Planning Authority Act to be of special significance to Aboriginal people. And with that comes these special treatment. And we refer to this as the special protections that apply to Part 3 reserves. So once they're proclaimed, they are vested in the Aboriginal Affairs Planning Authority for the benefit of Aboriginal people in perpetuity. So there's no end date to these reserves. And then the special protections that apply to them are that non-Aboriginal people must have a permit to enter those reserves. And if they don't have a permit, they commit an offence and can be prosecuted. Second, if government wants to cancel those reserves or change the boundaries or remove land, both houses of parliament have to approve that. So it's a really, really high bar for tenure rights and protection. Third, they're treated specially under the Mining Act in that the Minister for Mines must consult with the Minister for Aboriginal Affairs before giving mining companies permission to explore a mine. And lastly, the Aboriginal Affairs Planning Authority must also agree to the grant of any interest or right over that land, with the exception of mining and petroleum. And importantly for the amendment bill, when we've been talking to corporations about handing this land back, under the current Act, only the Aboriginal Lands Trust or the Aboriginal Affairs Planning Authority can manage that land, which means if we want to hand it back, we have to cancel these special protections. And what Aboriginal people have told the state, many, is that we would rather leave the land in the ALT estate than take one of those other tenure options under the Land Administration Act, like freehold or conditional freehold or reserves, which means in effect we have no way to divest those reserves as it is now. Just briefly on how the current divestment program operates itself. Importantly, the first step in any divestment program is that the ALT has a function under its act to use and manage the land in accordance with the wish of the Aboriginal inhabitants of the area. That's the wording in the act, and we're looking at updating that because it's obviously outdated and not appropriate. But importantly, that definition, there is no definition in the current act for that term, Aboriginal inhabitants, which means the ALT, when making a decision to hand land back, takes a very broad view and says we need to make sure all Aboriginal people who have an interest in that property, we're using that land in accordance with their wish. And they try to reach agreement between native title holders, any Aboriginal community governing body, other Aboriginal leaseholders, and other Aboriginal residents. So that's really the first step. Then there's a number of approvals. Once there's agreement there, we would seek the approval of the Aboriginal Lands Trust and various ministers responsible for the grant of tenure and approving tenure under WA law. When we talk about divestment, we're talking about the returning of land, so getting rid of the ALT's control and management of the land and giving it directly to Aboriginal people. And that can be in any tenure type. And the state government doesn't have a preference to the tenure type. A large part of our work is to work with corporations on what their aspirations for the land are and try to find a tenure type that best matches how they want to use the land. Really importantly as well, before the land can be handed back, the state wants to make sure that we've investigated any contaminations or hazards on that land and remediated it. Because the principle of divestment is that it should be at no cost to you to receive this land, and we don't want to be handing back land that will then be a liability or cost you money to remediate. So that's really, really important. And then importantly as well, native title approvals are required for any divestment. And so we would need an Indigenous land use agreement where native title rights and interests exist. And we have funding in our program to manage that and to cover the costs of PBCs for holding common law holder meetings and entering into an ILUA. I mentioned at the start that the legislative challenges are only part of the challenges of divestment, and there are other challenges that relate to that remediation of contamination and also funding for corporations to both engage with the divestment program itself, to meet with the state, have these complicated discussions, and then also to build their capacity to manage what is in some cases really large areas of land. And so we've managed to receive some funding to support Aboriginal stakeholder engagement in the program, and we can provide costs within our program for travel allowance, director fees, and venue hire and catering to hold workshops with groups. We can also fund legal advice for groups when they're accepting land to review tenure documentation and Indigenous land use agreements. And then there's also some capacity building support that we're able to investigate as well. So where there would be an activity that would support a corporation building its capacity to then manage the land, we can provide funding for that. So things like reviewing governance or land holding body arrangements, or strategic land use planning and environmental consultants or economic opportunity assessments. And I guess the other key thing to just note here is the way this program is funded at the moment is we're working with government on a 4-yearly basis to do tranches of divestment, and we're trying to prioritise the divestment of those properties that stakeholders are telling us are priorities for them. So 285 properties, 21.9 million hectares will take a long time to divest. And we're working iteratively with different corporations who are either approaching government or we're trying to approach people as we can and work through properties on a case-by-case basis. In some cases, there might be significant costs involved in that. especially when we're talking about the divestment of a community itself or areas where there are particularly high levels of contamination requiring remediation. And what our commitment is there is to work with in partnership with those corporations on divestment proposals. And in some cases, we may need to seek further funding from government where it's beyond the funding that we currently have in our program. So that's a bit of a high-level overview of the divestment program. And the next part of the presentation is to take you through really the 6 key reforms that we're proposing in the Act. So I'll talk to each of those one by one. This slide is an overview of those 6 key reforms. So just briefly, before we get into the detail, the first one is about updating definitions and making sure the Act is cognizant of the Native Title Act and complies with the Native Title Act, which it already does. But given the significance of the ALT estate to Aboriginal people, it's a lot of the feedback we've received is that it's important that the Act recognises that. The second is that the Aboriginal Lands Trust duty, which I mentioned briefly before, to consult with Aboriginal people on any divestment, it's currently not certain because who the ALT has to talk to is not defined in the Act. So we're looking at updating that to make it really clear who the ALT must consult with before it makes any decision to divest. But really, this is about establishing the practice that the ALT has already taken to consult with all of those Aboriginal stakeholders. And then the third change is really the key change in the amendment bill that is hoped to remove one of the biggest barriers to divestment, which is to make it possible for control and management of those Part 3 reserves to be given to an Aboriginal corporation with those protections remaining. And there's a whole framework we've had to build in the Act for how that will work, which we'll talk through in detail. The fourth change is then, if we've given control and management of an Part 3 reserve to an Aboriginal corporation, we also want to have an ability for that corporation to manage the entry permit system itself. And so we're looking at doing that under delegation. The fifth change also relates to those Part 3 reserves, in that in some cases, Aboriginal corporations may not want the Part 3 reserve, and they may prefer to hold the land in freehold and have direct ownership. Currently, under the Act, it's a very lengthy process in order to deed-proclaim that land so that we can hand it back to an Aboriginal corporation in another tenure. So we want to look at some changes to make that process quicker and easier where there is full agreement. And then lastly, as I mentioned at the start, we're now looking at updating trespass enforcement as a result of stakeholder feedback. So I'll talk you through all of those changes too. So the first two are quite small in nature, and we'll get through quickly. And then the bulk of the discussion is really going to be on those Part 3 reserves and the subsequent 4 changes. And just a reminder, so the exposure draft is available in full on Have Your Say WA, and we have a guide that's been prepared to support a page turn of the amendment bill and explain the policy intention. This presentation won't go into every single change in the draft, but is really intended to give you a high-level overview of what the key changes are and how they will work in practice. So starting with the first one, definitions of native title. So there's 3 key definitions that relate to the amendment bill that I want to talk through. The first is a definition of Aboriginal corporation has now been introduced and is defined as a corporation under the CATSI Act. And the reason this definition is particularly relevant is in relation to Part 3 reserves. So the ability to make a control and management order in relation to a Part 3 reserve will apply to Aboriginal corporations. And the reason behind that is that the CATSI Act provides that the corporation must have Aboriginal ownership. And it's really important that a Part 3 reserve, because it's for the benefit of Aboriginal people broadly, is managed by a corporation that has that Aboriginal ownership. And also, given all of the framework that sits around Part 3 reserves and the trespass and the permit system, it's important that there's some governance requirements around the management of those corporations. And the CATSI Act provides a lot more rigour around those sorts of things. The second term used throughout the bill that you'll see is Aboriginal entity, and that's a broad term used to capture all Aboriginal corporations under any legislation in WA. And that's important as well because any divestment could be to any Aboriginal entity. There isn't that requirement that it's a corporation under the CATSI Act. That requirement only applies to the Part 3 order that would be made. Lastly, we're replacing the current Act uses outdated definitions of persons of Aboriginal descent that doesn't align with how current legislation defines Aboriginal person. And so the amendment bill introduces a new definition of Aboriginal person, which is the 3-part definition used from the Mabo decision. And that's a person who is wholly or partly descended from the original inhabitants and identifies as an Aboriginal person and is accepted as an Aboriginal person by a community in which they live. So really that change is about bringing the Act into line with other legislation across Australia. And then the next change is in relation to native title. So as I mentioned when speaking through the divestment program, whenever we change tenure under WA law or grant any tenure rights, including to divest land, that would be a future act under the Native Title Act and requiring Indigenous land use agreement with the native title holders. That is already the established practice of the ALT divestment program. However, feedback we've had from stakeholders is that it's really important to confirm that the Act operates consistently with the Native Title Act, given that the Aboriginal Affairs Planning Authority Act was made in 1972 and predates the Native Title Act. So we've inserted a new clause, 6A, which provides that the Act does not affect the operation of the Native Title Act. And we've also got now definitions of native title body corporates and native title claimants under the Native Title Act as well. And they are defined stakeholders that the ALT must talk to in any divestment proposal, which is consistent with how the ALT already makes divestment decisions. And this brings us to the next reform, which is on consultation on divestment. So under the current Act, Section 23C outlines one of the functions of the ALT, which is to ensure that its use and management of the land for which it's responsible, which would include divestment of that land, accords with the wish of the Aboriginal inhabitants of the area, so far as that can be ascertained and is practicable. And so the ALT currently takes a broad view because that term Aboriginal inhabitants isn't defined, and make sure it consults with all Aboriginal stakeholders. However, a lot of the feedback we've got from Aboriginal stakeholders is that there's uncertainty about who the ALT will talk to when making a divestment decision. So the changes to this section, as you can see, are quite minor, and they're to replace the term Aboriginal inhabitants with a defined term, Aboriginal stakeholders, to make it clear who the ALT will speak to in any divestment. And the definition of Aboriginal stakeholders are all those people that the ALT already requires that government speak to before any divestment decision is made. So in practice, where we're divesting land, there's a requirement that there's agreement between and that the ALT consults with any registered native title body corporate who holds native title rights and interests over the land, or a native title claimant claiming interests over the land, any Aboriginal corporation that is responsible for governing a community on the land, any Aboriginal resident otherwise not represented by that community, any Aboriginal leaseholder who might hold a lease from the ALT over the land. And lastly, there's also an ability for the Aboriginal stakeholder for the ALT to determine an Aboriginal stakeholder to be a requirement for consultation. And that's important because some of these sites are really significant to Aboriginal people across Australia. There might be former missions where a lot of Aboriginal people have a connection, and the consultation requirement might be broader. But importantly, between this new definition of Aboriginal stakeholder and that function of the ALT to use and manage the land in accordance with the wish, there is no hierarchy of interests in that land. All of those stakeholders are equal in a divestment decision, and where there's disagreement on how that land should be divested, the department and the ALT's approach is to fund workshops and mediation and to try and work through the different tenure options that might be available to try and reach agreement. And I acknowledge that this is still one of the biggest challenges of divestment, and it's something we're continuing to work with. But in terms of the amendment bill itself, it's really important that all of those stakeholders have an interest in that land and will be consulted on divestment. So the next part we want to talk to is the reforms around the Part 3 reserves. And really all of the changes from here relate to those Part 3 reserves, which, as I mentioned, there's 81 of those currently, but they make up 93% of the ALT estate. And I'm going to talk through how that framework will work in a divestment context now. So there's really 6 key parts of the amendment bill that we want to speak to you about in relation to handing control and management of Part 3 reserves back to Aboriginal people. The first is that when we hand that land back, we want to ensure that it can be used for a wide range of uses that Aboriginal people might want to do on the land, which would include economic activity. And so there's some changes there in relation to the purpose those lands are proclaimed for and the underlying reserve purpose under the Land Administration Act. The second part of the framework is that vesting of the land in the Aboriginal Affairs Planning Authority is really important because it provides for the trespass and the enforcement of trespass and the permit system under the Act. And it also provides that if anything ever happens to the corporation that might be managing the land is still vested in the authority and remains a Part 3 reserve. So that Part 3 status of the land won't be lost through the divestment or subsequent revocation if that should happen. Then we have an ability for the authority to make an order placing control and management with an Aboriginal corporation. And that would operate similarly to how management orders under the Land Administration Act operate. And it would still completely remove the Aboriginal Lands Trust from the picture and from any right or responsibility in those reserves. Then fourthly, because that vesting in the authority is going to continue, we need to restrict the authority's power over the land once a corporation has the control of management. So it's clear that the corporation has the full kind of decision-making authority and the control of management of the land. Then fifth, there's an ability for the authority to give the corporation the power to lease and sublease as well, so that it can activate the land and use it as it needs to. And lastly, there's an ability for the Part 3 order once made to be varied with agreement if it's not working and if anything needs to change, or to be revoked if the corporation no longer wants to manage the land, goes into administration, or is otherwise not complying with one of the essential provisions. So I'll talk through each of these in the next few slides. So starting with the broad purpose of the land. Currently, we have a reserve created under the Land Administration Act. And when reserves are created, they're given a purpose that that land is used for. So like a recreation reserve that's managed by the local government, most of these reserves are created for a purpose similar to the use and benefit of Aboriginal people, which is sometimes not quite flexible enough to ensure the broad range of uses that corporations might want to use the land for. And then separately on top of that reserve, you've got the vesting with the Aboriginal Affairs Planning Authority and the proclamation that has a purpose attached to that as well. And so what we want to do when we're divesting this land is make sure that that purpose is broad. And in some cases, we might want to change the underlying Land Administration Act reserve to make its purpose much more broad, something like the social, cultural, economic benefit of Aboriginal people, to make it really clear that that land could be used for pretty much any purpose you can think of would fit within that purpose and provide as much flexibility as we can to Aboriginal corporations wanting to use that land. So these sections together make it clear that when we're handing land back, we can also change the underlying Land Administration Act reserve. The Minister for Aboriginal Affairs can request the Minister for Lands to change that purpose, to update it to reflect that new social, cultural, economic purpose. And then it's important that if we are changing that underlying reserve purpose, we need to make it clear in the Act that that doesn't impact the status of the land as a Part 3 reserve, and that those special protections that apply to the Part 3 reserve continue and are not impacted. So we've got Section 26 and 25A together provide for the continuation of the benefits of Part 3 and those special protections, even where we're changing the underlying purpose. Then we've got the vesting in the authority. So that vesting in the authority is really essential to the protections that apply to that land, being that the land is there for the benefit of Aboriginal people in perpetuity, there's no end date, and that there's consultation with the Aboriginal stakeholders on the ground regarding any use and management of those reserves, the parliamentary oversight that applies to that land, including that protection against the cancellation of the reserve or any changes to the boundary, and also that permit system and trespass system on the land. That vesting in the authority are really essential to allow government to enforce trespass and have that offence of trespass and fines. And so the situation we have it as it is now is you've got that Land Administration Act reserve that's vested in the authority, and then a control and management is given to the trust. So what the amendment bill proposes is that there'll be a new option to remove the trust entirely and for the authority to instead give control and management to an Aboriginal corporation. And that's Section 37 of the Act that provides for that. And that control and management can be given to an Aboriginal corporation or two or more Aboriginal corporations jointly. There may be cases where multiple Aboriginal corporations want to manage land together. Section 38 also provides that a Part 3 order cannot be made unless recommended by the trust. And that's important because the trust has that function under the Act to make sure that it's using the land in accordance with the wish of the Aboriginal stakeholders. So that again provides that any Part 3 order would follow that same divestment process, requiring agreement of those Aboriginal stakeholders. And really the intention is that the conferral of a Part 3 order only occurs after extensive consultation with Aboriginal stakeholders and where there's support for a divestment outcome. Then there's a subsection that allows that order to be on conditions, and that's similar to any different tenure arrangement under state law, that there would be a deed attached to it that outlines the standard conditions for managing the land. And that would be informed by consultation from the department across government, including with Department of Mines and any other interest holders in the land, including where there might be tenement holders on the land. And it would be negotiated between the state and the Aboriginal corporation taking on the land, and we would fund independent legal advice to review and consider any conditions. And really importantly, once that Part 3 order is made, the trust is no longer in the picture in that arrangement. So the ALT has no function, no power, no duty, no referral requirement in relation to a divested Part 3 reserve. Also, once we've made the Part 3 order to an Aboriginal corporation, it's important that the responsibility for the day-to-day management of the reserve sits with that Aboriginal corporation. And so we need to provide for a restriction of the authority whose vesting is still there and what powers the authority can exercise. And so the authority won't be able to exercise any of its powers unless the Part 3 corporation consents to that, or the Part 3 corporation is not complying with an essential condition, or the conditions of the permit of the order have already permitted action. And there are some exceptions to that where it's the powers of the authority are necessary for those special protections. And you'll see that under Section 38C of the Act. Then there's also that requirement for consultation. So under Section 30 of the Act, it provides that no right interest can be granted over that land without the approval of the authority. So that means that if government wanted to grant, say, an easement to a service provider, it would need the authority's consent to do that. Currently, the authority seeks the views of the trust. And so importantly, we need to replicate that where we've divested the land to an Aboriginal corporation, that the authority, there would be a requirement that the authority consults with the Part 3 corporation instead of the trust. Also, I mentioned that special treatment under the Mining Act, in that the Minister for Mines must consult with the Minister for Aboriginal Affairs before making a recommendation to consent to mine under any mining or petroleum legislation. And then the ALT separately has that consultation requirement with Aboriginal stakeholders. Where we've divested the land to an Aboriginal corporation, that consultation between the Minister for Aboriginal Affairs will just be directly with the Part 3 corporation managing that land. So the consultation is equal to what occurs already with those Aboriginal stakeholders, but it's streamlined because you've now got one point of contact and the ALT is no longer in the picture. And we're hoping that will streamline some of the management of these lands once we divest them, because the ALT, as you know, currently only meets 6 times a year, and it can take a long time to get them to consider something. So because they also then have to consult with the stakeholders on the ground. So by making it streamlined to just the Aboriginal corporation managing it, hopefully the day-to-day management will happen a lot quicker and easier. Then once a Part 3 order is made to an Aboriginal corporation, the authority can give that corporation the power to grant leases and subleases over that reserve. That power would remain subject to the consent of the authority under Section 30, because it's important that the authority would be able to know what leases are granted over the land in the event that the Part 3 order is ever revoked or the corporation is no longer managing it. But really, this is not intended to provide oversight of the decision-making of the corporation or displace the decision-making role of the corporation. In practice, it's going to be more of a procedural approval, similar to how it's done under the Land Administration Act, in that in which case it's delegated to officers of the department, and they're checking that essential conditions of the lease are there and that the lease is within the purpose of the reserve and the term of any interest is consistent. But we have heard from corporations that might not want to seek the approval of the authority for every lease. And there is a pathway provided in Section 38E for a corporation to be able to grant leases without the approval of the authority, where we've agreed a template lease that includes those essential provisions, and there's an agreement that those leases will be registered. So there's an awareness of what leases and interests are granted on the land. And that's really intended to be able to streamline the corporation's management of the land and remove that approval requirement once we agree to the standard conditions. So that's really the framework for how a Part 3 order will work. In terms of how we get to that point, once the amendment bill is made, the divestment of a Part 3 order would follow a very similar process to divestment in any other tenure. So we've got the first requirement that the ALT and the Minister must approve divestment, and that would be following consultation with all those Aboriginal stakeholders. Once that's agreed and supported, the department would then undertake referrals across government, seeking comments on divestment, including with the Department of Mines. The Department of Mines also consults with other interest holders on the land under its legislation. So any tenement holders would be consulted, and any responses to that discussion would be considered by the department and Department of Mines, and there might be conditions that are proposed as a result of that. That would then be negotiated with the Aboriginal corporation requesting divestment. The authority would then approve the grant of that order, and where native title rights and interests exist, we would enter into an ILUA with the native title party. The authority and the Aboriginal corporation would then execute the order and the agreement that attaches to it, the deed, and those documents will be required to be lodged at Landgate to effect divestment. And importantly, once that divestment occurs, there's a number of provisions in the Act that provide that any existing rights, leases can continue, any existing mining tenements and entry permits that exist before the land is handed over can continue unaffected. And that's really important to provide that certainty for existing interest holders that this proposed divestment won't derogate from the rights they already have. So then on to variation and revocation. So because the vesting in the authority is remaining there, it's important that we need to be able to update that Part 3 order. There's no end date to it. Once it's made indefinitely. And we need to be able to update those conditions over time. So 100 years from now, there might be something that's changed into how that land's working that needs to be updated. But that order can only be varied with the consent of the Aboriginal corporation managing the land. And then secondly, there is an ability for the authority to revoke the order, but only where the Part 3 corporation consents. There might be cases where the corporation no longer wants to manage part of the land or all of the land, or if the Part 3 corporation is not complying with one of the essential conditions of the order and the leasing order. And what those are would be negotiated between the state and the corporation receiving management of the land prior to divestment. So it would be really clear in that agreement what the grounds are for revocation. And it really would be quite limited to where there's essential things that are not working or not being complied with. But I think really importantly as well, if a Part 3 order is ever revoked, that won't impact existing leases that might be granted. There'll be an ability for those to be continued and assigned to the authority. So if there are communities or other Aboriginal corporations who have an interest in the land, those interests won't be affected. And it also won't remove the land from Part 3. So if the authority revoked a control and management order to an Aboriginal corporation, we would be back in the case we are now, in that we've got ALT land, the government's made a commitment to divest, and it would be incumbent upon the state to then work with Aboriginal corporations again to find a way to divest that land again. So the vesting is really good in a sense in that it ensures that land is never lost from the Part 3 reserve. Even if it's revoked, it's still there as a Part 3 reserve with those protections and managed for the benefit of Aboriginal people. And then we move on to permits. So because we've got an opportunity to hand land back to Aboriginal corporations, some corporations might want the power to grant permits themselves. Currently, the power to grant a permit sits with the minister and it's in the regulations. So the first change in the bill is to modernise the permit process by making that power directly in the Act. So the power to grant the permit has been taken from the regulations and put into the Act itself. Then if the minister divests a Part 3 reserve to an Aboriginal corporation and retains the ability to grant the permits, it's important that the minister has to consult with the Part 3 corporation managing that reserve before granting any permits. So there's a section that provides for that. Then we've got a new section 7A that allows the minister to delegate that permit power to an Aboriginal corporation. So the corporation itself can grant permits. And lastly, there's that ability, the provision that provides certainty to everyone that existing permits aren't affected by the making of a Part 3 order or by the delegation of a permit power. So the first part, just to give an overview of how it currently works. Regulation 8 of the Aboriginal Affairs Planning Authority Act regulations gives the minister the power to grant permits, and it provides that before granting a permit, the minister must consult with the Aboriginal Lands Trust, who has then that function to consult with Aboriginal stakeholders on the land. And what we're doing in the amendment bill is removing that regulation and putting it in the Act. So the Act will say that the minister can grant a permit authorising entry, that permits can be issued subject to conditions, and that permits can be revoked. And really that's about modernising the permit system to make it really clear in the legislation where it is, but retaining the existing system and supporting a consistent administration of that. So in terms of consultation, so how it currently works is that the minister, before granting a permit, must consult with the trust, and the trust then has that function under Section 23C to consult with all those Aboriginal stakeholders. There's also a requirement that if the minister decides to grant permission contrary to the views expressed by the trust, the minister must provide the reasons to the trust and table those reasons before Parliament. And what the amendment bill seeks to do is replicate that for an Aboriginal corporation where they're managing it. So if the minister has the power to grant the permits, it must consult with the trust or the Part 3 corporation, whoever's managing the land. If it's the Part 3 corporation, then the consultation just occurs directly with the Part 3 corporation, and there's not that further requirement because all of that consultation for who should hold the land has happened prior to divestment. If the consultation is with the trust, then the trust still consults with those stakeholders. And then equally, if the minister grants a permit contrary to the recommendation of the trust or the Part 3 corporation, that reason for that decision has to be tabled with Parliament. And then we have an ability for those corporations who want to have full control of the permit system themselves to seek a delegation from the minister. And delegations must be publicly available, and they can also be subject to conditions if required. And importantly, a Part 3 corporation is not required to accept the permit responsibility. They may prefer that the government retains the functioning of that, noting that there's the requirement that the authority consults with the corporation anyway, and that if he goes against their recommendation, it has to go to Parliament. And that the minister can continue to grant those permits where a delegation is not requested. But really, the ability for there to be a delegation is about giving that control and management and self-determination and authority to Aboriginal corporations. And there would also need to be further consultation across government for that to happen, which might be informed by the management of that land as a Part 3 reserve as well. And that goes to the process. So how it'll work is that a permit power can only be given to an Aboriginal corporation that's been divested a Part 3 reserve, so the Part 3 corporation. And the Aboriginal corporation can then request the delegation. The minister would refer that matter across government and seek comments and would consider how the management of the reserve is going. That would be a relevant consideration, and would negotiate any conditions on the delegation with the corporation. If the delegation is approved, it would be made publicly available. So it's clear to anyone wanting to access those reserves or transit who has the power to grant the permit. And importantly as well, the centralised system, ALPS, the AAPA land permit system, will be retained. And we've already obtained some funding from government to investigate how we can update the system to allow corporations that have that delegation to feed in and have that system either refer to theirs or use that centralised system. So really importantly, we don't want to change the process people already go through. This is about keeping the current process and status quo, but providing the decision-making role to the Aboriginal corporation managing that land. And then lastly, we have that new section 37.6 that provides that any existing permits are not affected by the delegation of the permit power or the divestment of a Part 3 reserve. So any existing permit applications would continue to be processed and existing permits remain valid. And that's an important assurance to provide for existing interest holders. So just because there's a lot of detail in all of that, there's a table here that kind of details how it will work going forward and those two pathways. So the first column is how it operates under the current Act. And then we've got those two options, one where the minister retains the permit power and the second where the power is being delegated. So firstly, there won't be any change to who requires a permit or the requirement to obtain a permit. That's going to continue no matter what. Existing permits will continue no matter what, and there'll be no change. And the process for applying for permits will be the same. In terms of who's making the decision, it could be that the minister retains the power or it's delegated to an Aboriginal corporation. They're the two options post divestment of a Part 3 reserve. In relation to who the minister must consult with, Currently, he has to consult with the ALT, who must consult with Aboriginal stakeholders. If it's divested to an Aboriginal corporation, the consultation will be directly with the Aboriginal corporation managing the land, or there won't be consultation because the corporation itself is the one granting the permits. In terms of the power for granting the permits, currently it's the minister who can grant or refuse, or it'll be the Part 3 corporation. In terms of mining consent, the consultation on that, the Minister for Mines must consult with the Minister for Aboriginal Affairs, who must consult with the Aboriginal Lands Trust. And if it's divested, the Minister for Aboriginal Affairs will have to consult with the Part 3 corporation. The Minister currently is the one that can set conditions and revoke permits, or it'll be the Part 3 corporation. And currently, the parliamentary process applies that if the Minister goes against the recommendation of the ALT and grants a permit, then he must table that decision at Parliament. And likewise, he'll have to table that decision at Parliament if he goes against the recommendation of the Part 3 corporation, or it'll be the Part 3 corporation making that decision. And so there's no requirement to table that at Parliament because there's no one to go against the recommendation of. In terms of review of decision, I think importantly, because this is under delegation, the Aboriginal corporation would be making, in effect, the decision of the minister. And so currently the minister's decision is subject to judicial review, and the same would be true for the Aboriginal corporation exercising the decision of the minister. So that's really the key big changes in the bill. The next two changes also relate to Part 3 reserve, but they're not as lengthy. So I appreciate your patience as we get through all of this detail and looking forward to questions at the end. So the fifth reform relates to making divestment easier and removing some of the red tape. And just to step back on what currently happens is if government wants to change the boundary of those reserves, of a Part 3 reserve, to excise land, so that we can give tenure to an Aboriginal corporation. Say some corporations might not want those Part 3 protections. They might want to hold the land in freehold or leasehold or as another type, or even portions of those reserves might be identified for particular projects that require a different tenure type to enable them. Or there are also a lot of roads, public roads that sit in these reserves, or public utility services like power, wastewater treatment plants and rubbish tips that might be better managed by those agencies. So those agencies could hold tenure and be responsible for the upkeep and maintenance of that land. Currently, if we want to take any land out so we can give tenure to an Aboriginal corporation or for a road or public utility, there's a requirement that that request is tabled at both houses of Parliament for 14 sitting days. And that makes any change to the boundary, because there might be multiple of these changes, really, really lengthy. And each individual change could take 12 to 18 months, which makes divestment quite difficult. So what the amendment bill proposes under section 25(6) and 7 is to create an exemption from the parliamentary requirements where the purpose of changing the boundary or cancelling the reserve is to either give tenure to an Aboriginal corporation in accordance with its aspirations, or give tenure to government agencies to manage roads or public utility services. But really importantly, that exemption from the parliamentary process can only occur after there's been that consultation with all Aboriginal stakeholders, and all Aboriginal stakeholders have agreed on the divestment outcome, or including the dedication of a road or the grant of tenure to service providers. And so it means that it can only happen where there's consent of Aboriginal stakeholders. And if that reserve is already managed by an Aboriginal corporation, then there's a requirement under the amendment bill that that corporation consents for that parliamentary process not to apply. So this change is just about removing some of that cumbersome process so that we can action the divestment easier, but it doesn't change the requirement for consultation or the agreement and to use the land in accordance with the wish of those stakeholders. And then lastly, we have the changes relating to enforcement. So currently under the Act, if a non-Aboriginal person enters onto a Part 3 reserve without a permit, they commit an offence and can be prosecuted. And what Aboriginal corporations have told us is that there are a number of issues with how the Act works that are impacting how well that offence is used as a deterrent, but also how prosecutions happen. So the first thing we're looking at doing is increasing the penalties for trespass on Part 3 reserves to make it more of a deterrent for people for doing that. We're looking at increasing the initial fine for $2,000 to $2,000, but also introducing a daily penalty. So if someone is on a Part 3 reserve without a permit, then they could be fined $400 for every day that they're on that reserve without a permit. And then the subsequent offence would be increased to $10,000. And there's that daily penalty as well. In practice, the Sentencing Act will also apply a corporate penalty to 5 times those rates where it's a corporation trespassing. One of the other big issues for deterrence is information, and we're aware as a department that there's not great information about these offence requirements of the trespass. So we're looking at working with other agencies as to how we can better get information out there that this permit is a requirement and a clear map of everywhere you need a permit for. And that's something we're working on to support the amendment bill as well. The second change in the amendment bill is for time limits for prosecution. Currently under the Act, if we want to prosecute someone who's trespassed, we have to do it within 12 months. And given the remoteness of some of these areas, it makes prosecution really, really difficult to do it in that time. So the amendment bill will increase the time limit for those prosecutions to up to 6 years, which will allow us to effectively manage a prosecution as an agency and work with the corporation to gather evidence where it is remote and where those matters can take time. And lastly, there's an ability that if we are recovering fines for a Part 3 reserve where it's managed by an Aboriginal corporation, those fines would be paid directly to the corporation because they're the ones impacted by the trespass. Okay, so that brings us to the end of the presentation. Really appreciate your patience with going through what I know is a lot of detail. We're going to, just to finalise and remind that submissions can be made on the exposure draft until Friday, 4 September. So Have Your Say WA has a full suite of materials. A recording of this presentation will also be available online, and we really encourage any submissions you'd like to make on the bill, either through the form provided there or any other written submission.